Hello friends, welcome back to my channel. Today we'll be discussing about a very important topic, that is electoral bonds. Electoral bonds have been described by the Supreme Court of India, and it is seen as a big blow to the National Democratic Alliance and Modi government, and opposition parties are hailing it as the victory of democracy. So we'll see what is it all about, why there is so much hue and cry, and what will be the consequences after the scrapping of electoral bonds. So let's get started. So first, we'll see what are electoral bonds. Electoral bonds are money instruments like promissory notes, which can be bought by companies and individuals in India from the SBI and rented to a particular party, which can then encash these bonds. The bonds are only redeemable in the designated account of a registered political party. A person being an individual can buy bonds either singly or jointly with other individuals. The bonds, which are sold in multiples of 1,000, 10,000, 1 lakh, 10 lakh and 1 crore. Electoral bonds can be bought only during specific window of time. Now, we're seeing what was the Electoral Bonds Scheme. It was launched in 2018. The scheme was announced in the budget speech of 2017 and started in 2018 to cleanse political funding in India. The central idea behind the Electoral Bond Scheme was to bring about transparency in electoral funding in India. Government had described the scheme as an electoral reform in a country moving towards a cashless digital economy.
As the world's largest democracy, political parties are essential ingredient of a multi-party democracy. Even 70 years after independence, the country has not been able to evolve a transparent method of funding political parties, which is vital.
So the government presented that the idea will be cleaning the political funding system in India. So the bonds were valid for 15 calendar years from date of issue, and no payment shall be made to any pay political party if the electoral bonds is deposited after expiry of the validity period. The electoral bond deposited by an eligible political party in its account shall be credited on the same day. So now we see who were eligible for these donations through electoral bonds. So the political parties registered under Section 29A of the Representation of People's Act 1951, which secured at least 1% of votes polled in the last general election to the Lok Sabha or the state legislative assembly, are eligible to receive electoral bonds. So till now we have seen that yes, the idea was very noble, and it had that potential to reform the electoral funding system in India. But then why did Supreme Court strike down the electoral bond scheme? What was the problems? The first problem was what the Supreme Court has observed. It is violation of right to information. The court held that the scheme, by permitting anonymous political donations, infringed upon the fundamental right to information under Article 19(1) of the Constitution. It pointed out that such a right is not only restricted to fulfilling the freedom of speech and expression, but plays a key role in furthering participatory democracy by holding the government accountable. Thus, it is not just a means to an end, but an end in itself. It highlighted that economic inequality leads to different level of political engagement because of deep association between monies and politics. As a result, there is a legitimate possibility that financial contributions to a political party would lead to quid pro quo arrangements. Second, not proportionally justified to curb black money. Relying on the proportionality test laid down in 2017 verdict in the case Puttaswamy case, which upheld the right to privacy, it understood that the government did not adopt the least restrictive method to achieve its objective. As an example of such least restrictive methods, the Chief Justice cited that 20,000 cap on anonymous donations and the concept of electoral trust, which facilitates the collection of political contribution from donors. The court also agreed with the contentions of the petitioner that since the purpose of curbing black money cannot be traced to any of the reasonable restrictions elucidated under Article 19.2, it cannot be said to be a legitimate purpose for restricting the fundamental right of information. Right to donor privacy does not extend to contributions made. The court pointed out that financial contributions to political parties are usually made for two reasons. First, as an expression of support, and second, as quid pro quo measure. However, it is understood that huge political contributions made by corporations and companies should not be treated at par with financial contributions made by another section of population like a student, wage worker, or an artist or normal people. Thus, the Chief Justice held that the right to privacy of political affiliation does not extend to those contributions which may be made to influence policies. The next point is what Supreme Court observed is that unlimited corporate donations violate free and fair elections. The court found out that the amendment made to Section 182 of Companies Act 2013, permitting unlimited political contributions by companies to be manifestly arbitrary. The provisions allow Indian companies to make financial contributions to political parties under specific conditions. However, through the Finance Act 2017, crucial changes were introduced, removing the prior cap of the amount that companies can donate to political parties, which was 7.5% of the average profit of the preceding 3 financial years. Additionally, the requirement for companies to disclose the names of the political parties to which contributions were made in their profit and loss accounts were also eliminated. So the Supreme Court highlighted that Section 182 errs by treating political contributions by individuals at par with those by the companies. Amendment to Section 29C of Representation of People's Act 1951 is also quashed. Initially, Section 29C of the RPA Act 1951 requires parties to declare all contributions higher than 20,000 and specify whether they were received from individual, person or companies. However, this was quashed by Finance Act 2017. Striking down the amendment, the court observed that the original requirement to disclose contribution of more than Rs 20,000 effectively balanced the voters' right to information with the right to privacy of donors, especially since donations below this threshold were far less likely to influence political decisions. There are some other observations by the Supreme Court also, and Supreme Court ordered that SBI immediately stop the issuance of any further electoral bonds and furnish details of such bonds purchased by the political parties since April 12, 2019 to the ECI by March 6, 2024. Such details must include the date of purchase of each bond, the name of purchaser of the bond, and the donations of the bond purchased. The ECI shall subsequently publish all such information shared by SBI on its website by March 30th. So, you can see that SC has been very critical about the scheme, and it has given directions to be made everything public so that transparency is ensured. But why have electoral bonds attracted so much of criticism? Wasn't it a noble idea? And why people were so concerned about it, especially the opposition parties? First concerns raised by the litigants or the opposition parties were first anonymity. Critics argue that the anonymity of electoral bonds is only for the broader public and opposition parties. Selling bonds via a government-owned bank leaves the door open for the government to know exactly who is funding the opponent. So, public and opposition parties may or may not know, but the government can know because the bonds are sold by a government-owned bank, that is SBI. Second, privacy. Privacy of the donor is compromised as the bank will know their identity. Third, unfair advantage allows the possibility for the government to either extort money from big companies or victimize them for not funding the ruling party, providing an unfair advantage to the parties in power. And you can see that more than 75% of all electoral bonds have gone to a party which is in power at the center. You can see through this graph. Now nexus. Like political bonds open up another route to further the unholy nexus between corporate houses and political parties. High denomination. One of the arguments for introducing electoral bonds was to allow common people to easily fund political parties of their choice. But more than 90% of the bonds have been of the highest denomination, that is rupees 1 crore. Cap on donations. Before the Electoral Bonds Scheme was announced, there was a cap on how much a company can donate to a political party. That was 7.5% of the average net profit of a company in the preceding 3 years. However, the government amended the Companies Act to remove this limit, opening the doors to unlimited funding by corporates. Even loss-making companies or shell companies can now be used to purchase electoral bonds. Opacity. Under Section 13 of A of the IT Act, companies contributing through electoral bonds will not even require to keep records of such donations. The RPA Act has been amended to exempt parties to inform EC of any amount received above 2,000 if made through electoral bonds, thus resulting in complete financial opacity. Foreign funds. The Foreign Contribution Regulation Act 2010 had been amended to exempt from scrutiny foreign funds received by political parties with retrospective effect from 1976. Black money. The amended Companies Act allows any foreign company registered in India to make contributions through bonds to political parties, despite doubts about who or where the real owners are. So we can see that there were a lot of criticism about, and with the SC judgment, it's been, I think, the concerns of the opposition parties has been vindicated by the judgment of the Supreme Court. Now, what will be the method of funding now, since the electoral bonds have been scrapped? How the political parties will be funded now? So I'm sure the government will come up with some other method, and they will not take the risk now because the elections are around the corner. But after the elections, the new government will surely bring about a new method of funding. But for now, the old system of funding will continue. Donors, individual or corporate, who contribute less than 20,000 to any political parties in a single tranche are not obliged to disclose details. But anyone donating above 20,000 will have to be disclosed. Their name have to be disclosed. The companies can donate 7.5% of the average net profit of a company in the preceding 3 years, and not more than that. Also, no foreign companies, no shell companies will be allowed to donate money to any political party. In conclusion, now February 15, 2024 stands as a historic day, with the Supreme Court's unanimous decision dismantling the Electoral Bonds Scheme. This verdict, founded on constitutional principles, addresses concern about transparency, privacy, and the impact on democratic processes, signaling a significant stride towards a more accountable and fair electoral funding system in India. But in my opinion, we need a better funding system in India. The present political system, the present donation system funding the political parties has been under criticism, and we must try methods like the methods used in US elections, or we can devise our own method which will be transparent, and but this needs a lot of political will, honest political will, I will say, and it also should be involving all the parties, so that their concerns are also taken care of. So thank you, friend. Thank you for watching the video completely. If you have any questions, you can put in the comments below. And if you like this video, hit the like button. Till the next video, I'll take your leave. Bye bye.